Good afternoon. How could it be 1:20 already? I can't believe it. Okay. So I'm just going to go ahead and call to order the conference committee meeting on Senate and House Judiciary. The first thing I would like to do is to just confirm that this is our second meeting of the second conference committee meeting on House Bill 2070. We had an agree to disagree, and we just need to, are you all still in agreement of the agree to disagree? Yeah, we can
Yes.
move forward. Okay. Yes, the restatement is we are putting House Bill 2510 into House Bill 2070.
Without the prior contents of House Bill 2070.
Yes, thank you. Mm-hmm. Okay, so I think that is settled, and we can go ahead and sign that conference committee report when it's available. One check mark. Okay. Yes. Yep.
We need to pass 2070.
2070 is not in this conference committee. We're just using it. Actually, it is in this conference committee because you guys are on that now. So it's perfect. Yes, it's perfect. Sufficient. And then we've got a couple of Senate bills that we talked about. But so I'll call those up. We were talking about Senate Bill 500. And I think there's a balloon ready for us to look at after our discussion yesterday, or where are we on that? Clear it up?
Yep. So I believe you sent the balloon.
We have this, but we were talking about it quite a lot about some.
Yeah, but there was a new balloon sent. There could be. Yes, this is.
So we had offered we countered to your offer. So let's just start with the counter offer. Okay. And it was to keep the balloon as is on page 8, but strike sections A and B of section 1 on page 8. Do I have that part correct? Yes. And then
otherwise leave it the same.
Yes.
Yep. Mm-hmm.
Yes.
Okay.
And the other part, I think it's the Senate's recollection that was the only change. That was the only part of the counteroffer. And we had agreed to that on the House side.
You remember the one part, I believe, but let's confirm here, that when we had mentioned that it should be by petition.
Right. And then we discussed that there's
not on the page 8, but on page 3, I believe it is.
And the Senate can discuss that. But remember, the whole point of the bill was it's a very confusing process to try to get your restricted driving privileges restored. And a petition is one more step that folks probably aren't going to know how to do. But
okay, if I may, I'm going to show you some language and you all just see what you think. Yes.
Thanks, Madam Chair. I had remembered that there was, I think it was relevant to this, some discussion from the chair last night, which I agreed with, that I thought some of the concern was ameliorated because, as was described, is that they would get this letter and that the letter would sort of lay out for them what their options were and what next steps were. And I had thought that we felt like we didn't need to say by petition because they would be given kind of very clear guidance in that letter. But, I could be mistaken on that, but that was sort of what I remembered. But I'm very willing to be corrected on that if I've misstated.
Is this a balloon offer from the House? Is that what this is? Because I don't think it's part of a different packet, but I don't think we've seen this language before. It's
Yeah.
okay if it is. We
Yeah.
just need to look
Yeah.
at it and consider it. On the microphone, please. On the microphone.
Thank you. That was the balloon that was created pursuant to our discussion yesterday.
Is it an offer from the House?
And I agreed with Senator Corson that you know the letter, and I was thinking more along lines that was the balloon on page 8, and then this was something different. But we're so yeah, take a look at that language and see what you all think.
You know, we had someone from the Department of Revenue here earlier. If he's listening online, perhaps he could return and answer the representative's questions offline so we can proceed with some other business. So I'm going to put aside Senate Bill 500 for now.
Okay, I will just say I just got a text message that we're voting on the budget, but it will be quick and we'll come right back.
Sure, we can
Okay.
stand by. We'll
Okay.
stand at ease.
Okay, we'll run down.
Thanks for joining us again. And then we have a complete balloon, I think, of where we are. Just this page. So the Senate will accept the House's offer of the balloon on page 3.
Okay, thank you. And
So is the revisor clear on, so I guess we need the House to accept striking section A and B of section 1 on page 8.
yes, so we are in agreement on that balloon piece that you provided. Yep, thank you.
And then we will need a CCR to sign on Senate Bill 500. Okay, great. Thank you. And then there was a proposal from, well, let's take the last thing we were talking about last night and go ahead and do the Senate Bill 458. Senate Bill 458, there was a Senate offer that was
Yes, and
on the table.
the House would like to make a counteroffer.
Okay.
And do we have that? Thank you. So just to reiterate, from the Senate offer, we did agree to the Senate's position on the reporting. And then this balloon has to do with the federal adoption. And we have found some language that I hope will be agreeable to you all. This is taking part of the balloon amendment that you had, and it's adding the underlined portion to it. So we're adding one, instead of just A through E, it's now A through F. We've added C. The agency makes such requests in conjunction with a request for federal law enforcement authorities to adopt the criminal investigation related to the seizure. And then we have also changed what is now F to be 10,000 rather than 75,000.
Thank you. Let us confer for a moment, and I'll probably have to try to find our third conference committee member, but just give us a moment, please. Thank you for standing at ease for a moment so we could confer. And the Senate did have conversations in the hallway with the stakeholders who have been involved in helping put the bills together that had passed both the House and the Senate. And that included representatives from prosecutors, law enforcement, KBI as well, and also some of the proponents of the Senate bill as well as the House bill. So the Senate has had those conversations just to make sure, is this something that you all would find workable and something that would help protect the liberty and rights interests of those who are involved in this procedure because they're in Kansas. And we did get agreement with a question about subsection F and the proposal for the threshold amount. We heard that $25,000 was in alignment with a federal threshold. So, thinking that if we're talking about federal adoption, perhaps it would be a good idea to have a $25,000 threshold. We heard that a neighboring state has a $25,000 threshold. Another neighboring state has a $50,000 threshold. 25,000 is not quite halfway between 75,000 and 10. It's closer to the 10. So that would be our only counter offer is the $25,000 threshold in subsection 1F. And okay.
Thank you, Madam Chair. Yes, we would be in agreement with the 25,000.
Okay, great. Then if we could
just reiterate, also, there was a piece in your first offer that had to do with the fee shifting and the jury trial, and that, we did not want included. We both of our bills were initially fine with the fee shifting. So that, if you recall, you had offered yesterday, if there was a jury trial, then we wouldn't do the fee shifting. But just to reiterate, I think yesterday we made it clear that we weren't in favor of that, but I wanted to make sure that all the parties understood that with the reporting, we're going to take the Senate side. The fee shifting, we're just going to stay with what both of our bills said initially. And then we would come your way with this added language.
The Senate is clear on what the House position is on jury trials, yes. And we, as the purpose of conference committee is, it's important to have discussions. And this agreement today represents a lot of hard work by this conference committee and by others as well. And it is an incremental step in reform that hasn't happened very significantly to this process since it was enacted 30 years ago. So, again, it's an incremental step towards further reform that will be, I think we have an agree instead of agree to disagree to be prepared. At least we do on our side and on the House side as well. So if we could then proceed with that, that would be great. Thank you. Next, we will take up the offer on House substitute for Senate Bill 232. And the offer from the House was to gut the contents of that bill and insert the contents of House Bill 2653. And the Senate is willing and does accept that offer. And however, I think we have an agree to disagree on our side on that.
Okay. Thank you so much. Yep. Mhm. Absolutely. So it seems like we do have an agree to disagree.
Thank you. And then that's next is a House bill. So if you want to pull that up.
Yes. So we now would be talking about House Bill 2144, which is organized retail crime. And the House position is we do have some amendments that we'd like for you all to consider. And then I'm just going to let you know, we also would ask you to add in the contents of 2676. So, but step by step, probably it works best for you to look at our amendments to the language in 2144 first, if we do have a balloon on that. And I could go ahead and explain it if that would be helpful. So you all will see on the first page, we are just taking out that number 1, that is the definition of organized retail crime, because number 1 was just theft. It was not acting in concert or in cooperation with anyone. It was just a single instigator of the crime. And so we decided to take that piece out. We kind of address it a little bit later, which I'll tell you. And so then we have the what the elements of organized retail crime are, and now it's become A and B and A1 and 2, or A1, 2, and 3. And then we changed the threshold from 3,000 to 5,000, and then we changed the threshold from 15 to 25. And then we added in a more severe penalty of $100,000 or more. We also changed some of the severity levels. We lightened up the one that was it's now 3, but it would be 5. We went from a 5 to a 6, which is less severe. And then in the next paragraph, we went from a 4 to a 5. And then in the last one, which was the most major amount, we kept that at a severity level 4, made that a severity level 4. So the levels are 4, 5, and 6 now, with some different thresholds of money. And then, if you all recall, section 2 is our theft statutes, and there was a change to those on page 3 in the italicized, and it had to do with property by deception. And if you look over now, so we would propose to strike those. If you look over at the what theft is in our statutes, you see on page 2, line 23, that deception is already covered there. So we felt like that was redundant. But then also for some protection for the single retailer that might not be experiencing what we would call organized theft, we did up some of the severity levels in numbers 1, 2, and 3 on page 2 to 4, 6, and 8, as you'll see. Yeah.
Sharing on the microphone, please.
So with respect to the provisions on page 3 that we've stricken concerning deception, as we understood it, those provisions were somehow distinguishing the penalties that would be pertaining to theft by deception from, for instance, death by, not death, but theft by threat. And we didn't see why that should matter. If somebody takes from you with threat, it should be treated the same as if it's by deception. So that's why we removed that.
And then
It's hard to hear you on the microphone, Representative Hearing. It's hard to hear online. So just make sure you speak into the microphone. Thank you.
And then I believe that the rest of it, there was one more change. Oh yeah. Would you like to explain that, Representative? And yeah, speaking of microphone.
So the only change that we had, it's a little unclear because some of these changes were made by the Senate. We're now talking about, let's see. Oh, I see. Yes. Okay. So the way the Senate bill as amended came to us, it said that the Attorney General had concurrent authority jurisdiction with the counties uh, to prosecute RICO, to prosecute organized retail theft, and to prosecute theft if it touched on more than one county. That's the bill we were presented. We talked with, I believe it was Mark Bennett and Sedgwick County, and he indicated that that's all good, but there could be instances where somebody commits one of these, I'll call them predicate crimes for jurisdiction, but they also in the course commit another crime that doesn't fall within this jurisdictional ambit. And he just wanted to make sure that they could prosecute all of those crimes together and wouldn't have to bifurcate the prosecution. And so that's why we've added on page 8. I'll just start it 2 there. Notwithstanding any provision of law to the contrary, the Attorney General shall have concurrent authority with any county or district attorney to prosecute any crime. So any crime would be any crime when it is part of an alleged course of criminal conduct that occurred in 2 or more counties, and such alleged course of conduct included one or more of the following crimes, which is RICO, theft, or retail organized crime. So the change is to allow concurrent prosecution of any crime if it's committed in a course of conduct of one of these others.
Is that the end of the House offer?
Yes.
I'll ask the revisor, doesn't the bill on the concurrent jurisdiction as presented by the Senate already do that?
Madam Chair, so it does do that, but only for organized retail crime. If you look at page 9, starting at line 22, it said organized retail crime is defined in section 1 and any other crime that is part of such alleged course of criminal conduct. So for organized retail crime, it would allow that to happen, but for theft and RICO, it would not allow them to merge those other cases together. So this amendment would purport to remove it from organized retail crime and move it to the lead in. That way it applies to all of the list of crimes there.
Thank you. And the Senate will have to discuss. Thank you for standing at ease. The bill was brought to the Senate regarding organized retail crime. So that's what the testimony was about, and the presentation and the conferees were talking about organized retail crime. And so the Senate um, is comfortable with the changes as proposed by the House on page 1 of the bill. And then in section 2 of the bill, starting on page 2, we start getting into regular theft. And that's not what we heard much about in committee in our hearings, or what we were looking at on the Senate floor. So the Senate would not be comfortable going into the theft alone statute and changing penalties. I mean, we're open to hearing some discussion about those changes from the House, but we didn't hear any testimony about changing any of that. And so the Senate wouldn't be comfortable with the changes in section 2. And the Senate believes that, particularly on page 3, it's important to keep the definition, or I'll ask the reviser, aggregate retail market value that's used in section 1. Do we have a definition of that anywhere other than on page 3?
Madam Chair, if you look at
Oh, I see.
2,
defined
starting
in
at line
section.
5, and so that definition remains. If you were to either go back to the Senate version of section 2 or remove section 2 altogether, the definitional change would be fine because of that cross reference.
So if we don't accept the changes to section 2 of the bill as proposed by the House, we still keep the definition of aggregate retail market value on page 3.
Sure. So I'm trying to quite understand. So in the Senate version of the bill, you do make some changes to theft. They're on page 3 in lines 17 through 25. And so I want to make sure we understand it. Are you wanting to go back to the Senate version of the changes in theft?
And I want to be speaking correctly, and do appreciate the House taking up this bill with the Senate, understanding that the House hasn't seen this before. So I don't mean to say there's a Senate bill and a House bill, because there's just the Senate bill, but appreciate the discussion on it here. And I'd have to check with on the Senate position on lines 17 through 22 about whether we agree with the House offer that it's redundant and we don't need to restate it there. And then as far as, and we still do have a quorum present, even though we don't have a quorum present on the Senate side. Can we proceed? We can talk, but okay. He didn't walk out. He just had a phone call to take. So, and then in section, I'm going to take a break so I can go vote on the Senate floor. Thank you. I think we were talking about the jurisdiction part of House Bill 2144. I guess that would be you calling us back to order, Madam Chair, but
Hey, come on back.
okay, great. And the Senate is pretty comfortable with keeping it is as the Senate position rather than the counter, or excuse me, rather than the offer by the House, because again, the bill was, it's about organized retail crime. So we think the subject of the bill should be, or of this part of the bill should be organized retail crime. So we would reject the offer on page 8 and the offer on page 9. And that change that the Senate did, that was a floor amendment to change what the Senate Judiciary had worked on and had passed as well. And it was a floor amendment, a friendly floor amendment brought on behalf of the Attorney General and to clear that up as well. So we're comfortable with the Senate position regarding pages 8 and 9. And we're also comfortable with, well, we've already talked about the other sections. So if you want me to clarify what our position is, I can do that. Okay.
We do have one, I mean, I don't know if it's called a counter offer or whatever, but we do have maybe something for you to consider. So great, thank you for page 1, those changes. And we are fine with that jurisdiction piece on 8 and 9, just going with what you all prefer, because again, you all heard the bill, so we understand that. We are, and also I do believe you've rejected what we suggested on page 2, upping those regular theft, which is fine. We would ask if you would entertain striking line 17, and I'm singing through 25 because if we don't have those words aggregate retail market value in lines 18 and 21, then we don't need the definition on line 24. So we felt like that was redundant, and if you would be willing, or if you would consider taking those out. And if we did that, then there would be no change to the regular theft statutes, and this bill would just stay as organized retail theft. And so that would be what we would ask if you would consider.
Thank you. Question for the revisor. If we accept the counter offer by the House, do we then have a definition of aggregate retail market value?
Madam Chair, yes. So organized retail crime, if you look on page 2, the new crime that you're creating, that's actually where the definition is. It's in the first section. So section 2 is just a cross reference to section 1. So still be good.
So the Senate would accept the counter offer by the House regarding page 3, lines 17 through 25 to strike those. And then I think we're ready to move on with the rest of the proposal for 2144. Just a moment. Could we have the revisor make sure the revisor understands the agreement of the chambers?
Yes, thank you. That will be very helpful. So the agreement so far on 2144 is to accept the House offer here on page 1 and the I guess there's no, just page 1, the changes to the new crime of organized retail crime. You're going to completely remove section 2 from the bill because your agreement is to not make any changes to theft. And then you are going to accept the House offer related to jurisdiction.
No, reject.
Oh, okay. Okay. No further changes. Okay. Okay.
Okay, so I think we're good on House Bill 2144, what we want for that. And we appreciate your input on that since we had not heard that bill. And, your insights are helpful on that. We would also ask that we take the contents of House Bill 2676 and add that to this new crime of organized retail crime. This is a new crime of encouraging suicide. We can explain, we had 2 days of hearing. It was actually 2 separate bills on House Judiciary. And those bills did have some things that needed to be tweaked. And we ended up doing it this way with the new crime of encouraging suicide. And we passed it in the House. And I don't know the number.
We had one no.
Mhm.
Yes, please speak into the microphone.
Thank you. It was overwhelming. There was one representative that voted no, and I believe on that day we had 120 plus voting.
Well, can we have a brief statement from the reviser about what it does?
Sure. Thank you, Madam. After I keep my bill away. So House Bill 2676 would create the new crime of encouraging suicide, which would be knowingly encouraging another person to commit or attempt to commit suicide when the person knows that such other person has communicated a desire to commit suicide. And that encouragement has to be made proximate in time to the other person committing suicide or attempting to commit suicide. And it also has to substantially influence that other person's decision or methods used to commit or attempt to commit suicide. It would be a severity level 5-person felony if the person attempts suicide, and a severity level 4-person felony if the person does commit suicide. And then subsection C provides for definitions of attempting to commit suicide and encouraging a person to commit or attempt to commit suicide.
Thank you. Do we have any definition for proximate in time?
Madam Chair, that is not defined in the bill.
Do we have any? I'm just talking to the reviser for a second. And then do we have any definition of persuasive on
Oh, I see.
lines 23 and 24?
No, there is no definition of persuasive.
So then the court would be determining proximate in time and persuasive.
Yeah, or the jury, whoever ends up.
Who's the fact finder? Sure, jury trial. Of course. So yes, thanks for answering the questions. And let's see, this is a House bill.
Yep. And so this would be our offer, but I think Representative Lewis had something he might want to add. Or
Yes.
okay. Mhm.
Thank you, Madam Chair. So with respect to your question about the proximate in time, I looked up Black's Law Dictionary, and I believe it defines it as immediate or direct. I would expect the judge to instruct the jury along those lines. As to persuasive, I think that's something that the jury would understand. The judge wanted to, he could try to define that as well. If I might just explain that I spent quite a lot of time thinking about this and looking at this issue generally, and the concern raised was that although everybody wanted to take this on and ensure that we had a crime against this kind of behavior, we were also concerned about First Amendment issues. And I'll just be brief and say that I looked at a State versus Johnson, which is a Kansas Supreme Court case involving murder for hire. And in that case, the charge relied on our solicitation statute, which uses the word encouraging. It says to do a crime encouraging or requesting another person to commit a felony. And in course of the appeal there, the court focused particularly on the word encouraging, and the defendant who had been convicted was arguing two things. One, that it was void for vagueness, which the Supreme Court rejected, saying that they thought that encouraging was a word that was normally understood. And the defendant also said it violated his First Amendment rights to speech, which was also rejected. The court pointed out that we criminalize speech in a number of areas, whether it's fraud, child pornography, incitement to riot. There's a Supreme Court, a U.S. Supreme Court from 1949, which considered a union picketing case. The union was picketing and asking or demanding that the company enter into an agreement that would violate Missouri antitrust laws. And the court pointed out that where the speech is encouraging harm to another person or that the other person commit a criminal act, that wasn't protected by the First Amendment. So I think that the case of State versus Johnson gives us some grounds for believing that this statute, which puts some parameters on the speech, it's not just saying to somebody commit suicide, it has to be proximate in time, has to substantially influence it. The defendant has to have been told, or the victim, if you would, the suicide person has to have communicated the desire to commit the crime. And so I think those parameters should protect it against a First Amendment attack. I also looked at cases in other states, in Minnesota and California, where similar statutes had been considered. And without going into the details on that, I do believe that this statute is either distinguishable from a statute in Minnesota, which was deemed to violate the First Amendment, or in the case of California's case, that the encouraging suicide statute was actually upheld.
It's probably up to you to ask if there are any questions for the revisor from our side, but do you have any? Okay, then we'll have to discuss.
Okay, very good.
Senate accepts the House offer.
Okay, thank you. We appreciate that. And we'll just ask the revisers to go ahead and I don't know if we need to communicate again what we've done, but the contents of House Bill 2676 are now included in House Bill 2144 along with the organized retail crime. And any questions does anyone have? Okay, thank you.
And does that conclude our work? I'll have to check on that real quickly. Just a moment.
It's a correct.
There's two still in conference committee and not ready yet to pull those up or discuss those. So we'll have to just not at this minute, but adjourn and come back at a later time on those two. But with that, then if there's no other clarification needed on our work that we've done, then
Could I just ask if you know, I think the House is going back in at 4. I
so
don't
is
know.
the Senate.
Okay.
So possibly we can reconvene maybe at 3:30
Great. Okay.
if we need to. So,
Okay. Sounds
yes.
very good.
Okay.
You'll just let us know.
Absolutely. Thank
Okay.
you. And
Thank you.
we're adjourned.
Thank you.
Thank you.